I am looking at the time, and I see it's now January the 24th, 2026. And this is the court gallery. And I am woefully unprepared for starting the stream right now. But hey, I'm going to give you this anyway. This is what we're doing. Ladies and gentlemen, we're live. I'm choking on coffee. The cat has decided he doesn't like the fact that I'm about to go live, so he wants to just start meowing and being crazy right at my feet while I'm trying to get things started. That's the stream boss for you. But as far as the presentation that we have to watch this morning, we're going to start things off with Judge Johnson. She's got, oh man, she's got a couple of humdingers cases. One, she has somebody she needs to bless out. The other one, she has somebody she needs to lift up. And they're both rather interesting. Then we're going to go to Ohio with Judge Iorochi. He's got a frequent flyer he hadn't seen in a while, and he's really upset that he hasn't seen her in as long as he has. Then, oh, we all knew it was coming. Judge Simpson had another Toupe situation, but in amongst all that, he finalized and dealt with a certain situation with a nice old lady who, well, we previously saw her bringing mice to court. Well, at least the dead variety. And Judge Stevens, he's dealing with that Walker guy who refuses to pay the school district back, and I just wanted to do a follow-up for that, and it all starts right now.
Okay. People of the state of Michigan versus James White. Case number 25S01093SM.
Court, Your Honor, Courtney Rose on behalf of people. 9,900 points on behalf of James White, who is here.
Okay.
Please step out there. Can I go get my client?
Yes.
Yeah, is this Mr. White? Yeah. One moment.
Okay. Can you get that to Jessica? Charles. Jessica. Okay, Mr. White. Apparently, he's
just keep keeping settings. But she was out of
all right. Just checking to see how we got a bond violation on the sentence date. Okay, well, don't go out of town anymore. All right, well, we're here for sentencing. This is on a domestic violence and we have a bond violation too on a domestic violence. So what's the bond violation about? Is it a new alleged contact or?
No, what it is.
Oh, I see.
He doesn't have a phone, Your Honor, and.
Failure to contact and enroll in pretrial services.
Yes. He said he's been calling from other people's phones. I asked him if he himself had a cell phone. He says no. So I said, well, how would they call you back? So he's having a communications problem.
Okay, sir. I get it. You don't have a phone. So guess what? The burden is on you to call them first.
Multiple times, every time I call, I can't get to them.
They say he failed to contact and ruling preacher.
On that voicemail. Call back numbers, everything I need.
Well, no, yeah, and I need, comments files.
Well, it says if circumstances change and the court wishes the person to be supervised, then please provide a new order indicating well, it's gonna be moot now because we're going into sentencing. So let's see, what do you want to say? Have you looked at the pre-sentence report and is it accurate?
Yeah, I've had a chance to review it with my client, no corrections on the body of it.
Okay,
If you see the recommendation, and I'm fine with that, but I do want to say that in terms of employment, he's trying to get some time. He's trying to get work as a car porter, he's gonna get work.
as a who? Car porter?
Yeah, that's your, but he's gonna get work for Detroit Work Company, which I've had several clients. do that.
You know, I saw a listing for, I think I saw it on LinkedIn too. It's for like valet services at the Hudson's building downtown. It's what's the name of that? The valet company has a specific name. Let me see. It says it's operated by Metropolis, but let me see. You haven't had any luck getting any responses?
Job,
Yeah, for valet.
never applied for valet before, but I did have a license. So I'm pretty tired of it.
What was he applying?
Oh, he told me like, yeah,
It was a car porter, like moving vehicles from one lot to another.
Oh, kind of sort of like for a car dealership or something.
Yeah. But I basically had the job, but they seen my current charges and they decided not to move forward.
Yeah, that can happen. See here, I've just pulled it up. They're looking for valet drivers at the Shinola Hotel. That's downtown. Did you ever go on LinkedIn? That's where this is listed. There's an application right there. There's a whole lot of things similar. Valet lane attendant, Hollywood Casino, Greektown. Valet driver at the Book Tower.
Yes.
Valet bell staff, that's somewhere out here. Atrium Hospitality, Southfield.
I'm putting it on this.
One I saw, Les Stanford Chevrolet Cadillac. Lead service lot attendant and porter.
That's what I'm gonna write.
Did you try there?
She has.
I think I've been applying to warehouse.
Okay,
jobs.
do it.
I've been applying to a lot of jobs, but I'm gonna check those out.
Shuttle driver and service porter at Milliken Ford. Looks like there's a lot listed. And then, of course, I saw that valet position here that was, I don't even know how I found, I know how I found it. Somebody left something. I was trying to find out who the valet was. And they actually had a job here through Metropolis, who I think does the Shinola Hotel too. They do the new Hudson's building. But yeah, you gotta get yourself together though, so you don't, mess up your opportunities by having things on your record. All right, so what's the warrant out of the 17th District Court?
He said he's gotta take care of that.
Yeah, apparently, yeah. But what is it? What's the charge? Who?
I said it was back in 2018. I don't remember the
Why do you take care of it? You just waiting for it to go away? That ain't happening.
I don't know what it's called down there.
All right, counsel, was there something else that you wanted to say? I got stuck on the
I
employment.
was just gonna, a couple more things, ready. He does have his high school diploma, so he has finished high school, he's 27 years old. In terms of the probation, I did advise him about getting everything done up front, because we're putting off halfway through, this 24 months recommended. Other than that, I think, Mr. White's gonna try hard to get a job in the meantime.
Well, he should. He's got two children, 6 and 7 years old. So they're old enough to be aware. Okay. That's even more alert. 8 and 6. Mhm. Okay, what are you doing about school?
I'm trying to take the trade for carpentry.
Do you know where? Do you know where?
Yeah, they throw that work already signed up there, everything. I just gotta participate in a few workshops, but wait, they're gonna get approved.
You say it's at Detroit at work? Anything you wish to say, sir?
Some of the recommendations, I just gotta find a balance to complete everything, and sometimes that can be like kind of hard to do.
You got to do it. This is a criminal case. So this got to be your first priority, really, because if you don't do what you're supposed to do here, the rest of your life spirals out of control. You're not going to be there to get the job or to see the kids or take care of the family. So you got to focus on this and you got to focus on learning something. I don't know exactly what you did here, but I could tell you this. Nothing good comes out of domestic situations like that where you're arguing, you're fighting, you put your hands on somebody. It doesn't change anything. It's you may exercise some type of control or try to over the person. You may be trying to put some fear in them. But it doesn't make the person do what you want them to do. It may make them fear you and want to get away from you. And that ruins the whole relationship. But you gotta learn you can't make people do what you want them to do. You can only sit down and discuss what your joint goals are for the relationship. You gotta do that when you're not mad. When you both can sit down and have a good conversation about whatever the problem is. And then you could agree to disagree and go your separate way. That's okay too. Or you could say, you know what? We want to work on this. We don't have the skills ourselves, but hey, I don't know if it's a girl, but if she has a job with insurance, maybe she could say she could get counseling till you get your job and you both go to counseling and work on communication skills. There's always a better way to communicate. And that's half the problem. Somebody's yelling about something and the other person's not listening. So how do you solve a problem when nobody's listening to each other? They just, fighting and yelling back and forth and it's bouncing off of each other. And the problem is ultimately the underlying issue is still there. So you got to take some of these classes. Anger management is good because, it teaches you ways to cope and how to deal with stressors, which not only is good in a domestic situation, but in life. Like when some guy comes up to you and gonna try to, test your manhood. And you thinking to yourself, get out of my face. I'm not dealing with this. Whereas before, you'd have been like, who do you think he is? And the next thing you know, you're in a fight with him over the fact that, what? He said you cut him off driving? Or you looked at him funny? You could save your own life just by not engaging. And guys, sometimes things gotta hit you and run off your back. Because who are these people anyway? Half the people don't matter. And if it is someone that you care about and they do matter, this isn't the way to solve it. And then the worst part of it is it says your kids don't live here. But if you are around your children and something comes up, you're teaching your daughter, the beautiful 8-year-old. Well, pick a man that's kind of rough you up a little bit, because that's what my daddy did. He loved whoever he was seeing, stepmother, girlfriend. So that's how you express love. You don't want her to pick that up. And she got some knucklehead that's pushing her around. And you sure don't want the little boy, if you got a boy there, to pick it up and say, shoot, I'm going to exercise control like this. As my daddy did. He was all right. I'm going to turn out all right too. Because kids are smart, which you probably know, as your two are kids. They doing way more than we did back in my day. They amaze me. I just can't believe how smart they are. So they're watching and learning and picking up things every day. So these classes and things that they're asking you to do, you're going to benefit from them. And you may very well be one of those people that comes back and says, hey, I'm glad you sent me to that. I really learned something. So, anything else you want to tell me? Except for how hard it is and what you can't finish. That's not how we become successful in life, by looking at a situation and immediately saying what we can't do. That's a recipe for failure in anything in your life. You got to look at it and say, hey, I got this. Might be a little difficult, but I'm going to do this. Glass is always half full, not half empty. See, your mind makes a big difference on the outcomes in your life. And how you couch it, the way you talk about it. And the first thing out your mouth to me was, it's difficult. Yeah, getting up was difficult, but you did it. It wasn't promised. Nobody's life is without some difficulties. Everybody got a struggle. And you just don't know what they are. But we're people. We're faithful. We're most of us God-fearing. So we call on him. Ask for the strength. Have the faith. And you get it done. You call on him, he'll help you. You don't call on him enough. I know that. I can tell. You got the help you need right there. Anything else? I'm talking to him.
No.
Okay. Anything from people?
Mayor, I did reach out to the victim in this matter. She did not return my phone call. It's my understanding from the pre-sentence investigation report that the defendant and the victim are still in contact. That worries me. Additionally,
Well, there should be, because there should be no contact order. Let me see. What's this police report?
I'll just note, I'd like the court to pay special attention to the first sentence made there, under the circumstances surrounding the instant offense. I get concerned that the victim made the statement that I guess she was just too drunk. I hope that the defendant, through your sentence, can learn to take some responsibility for his actions.
Well, what you angry? Why you get angry? She was too drunk. Y'all shouldn't have been drinking there. But why would you get angry about it? You said you were throwing her all over. The question is why? You got something you need to work through? Sometimes it's nothing to do with her. It's something you got. And that's okay to have something to work through. A lot of people got something to work through, but you got to know you got something to work through so you can start to work through it. Because there's no sense in throwing somebody around. He got too much and it was emotional. Yeah. There's still a vital relationship. So why are you all in contact?
Yeah, reached out to me
She can't do that. She can do it. You can't say anything.
Yeah, it was not a long reading, and I did that.
Okay, sir. Did you read the order you signed? What did it say? So what do you think that means? Uh-huh. And if it had checked and it doesn't, may return to the address listed to retrieve belongings. That was the motel. No, it didn't say go there. So you don't have any contact with her. If there was a need for you to go get some belongings, should have told him. Then he knew what to do to come here to ask. Then we could have told you how to get some police escort to get it. What? I don't even know where she lives. Maybe not in Southfield. But you can't let her have the contact. Of course she gonna reach out. Y'all got some kind of trauma bond situation going on here. And you throwing her around and she's liking it and calling you back.
We just kind of move forward, with work.
Move forward means move just that forward. No contact. You go your way, she goes her way. You don't have kids, do you? So what's the point? You can't move forward while you're on my probation.
I'm saying move forward and take care of my responsibilities and get it over with.
Okay. Well, that's not what I was talking about. I was talking about having contact with her.
I won't have.
Oh, that's good. Because if I find out about it, you know where you're going. Yep. No question about it. Because then I know you hard-headed. You don't follow rules. You don't follow the court order. As much as I'd have sat here and talked to you today, and if you were to do that, that would tell me, yep, go straight to jail, quit talking. He don't listen. So that's what you got waiting if you do something like that. And if she calls you, just see the phone, block it. Don't text nothing back. That means no contact, no texting, no sending messages through people. Just let it go. You got 5 million other possible girlfriends you could get. And if this one is really meant to be, when you get done with this, have at it. You can go back. Okay? So, all right. I heard from the people, so the court's gonna follow this particular recommendation. He's drinking half a pint of liquor per occasion when he does drink, which that's a lot for one sitting. And the purported marijuana use on top of it. That's the recipe for disaster with 2 substances there. And I think the recommendation regarding the treatment is spot on because of the prior diagnosis. And a lot of people try to self-medicate by drinking instead of going and getting their treatment and taking any prescribed meds. So we're going to get you straight. Sentence to the court, 24 months of probation, $960 of probation oversight fees, fines and costs $500. I guess, did he spend more than 1 day in jail
3 weeks.
on this case?
Yeah.
You have nothing else? 3 weeks. The incident date on this was October 24th, 2025. So you didn't get out until when?
After that. So you adjusted the bonds.
Let's see what I did. If I did that, what did I do? November the 12th. I made it 5,000 personal. So that would be 12 days in November and October 24. 8 days there. That's 20 days credit. So 20 days credit for 20. 20. There is going to be some community service. You're going to do 2 days community service at a non-profit agency. No alcohol or unprescribed drugs. There will be continue to be testing. Substance abuse counseling with a mental health component. And the 22-week anger management class. We'll have no contact with the complaining witness here. Zoria Hutchins. Zoria Hutchins. Clear up the outstanding warrant that you have. You're gonna sign up for your vocational classes in carpentry over at Detroit at work. So obtain a job and pay a crime victim's rights fee of $75. There is $100 pre-sentence fee and a $200 counsel fee. You can get off this probation within a year. So that's after half of the sentence is passed. If you've completed everything, there's a form that you need to fill out. You can get it from probation. Tell us why you think you have completed what you benefited from. Probation will weigh in on it. Tell us how your compliance has been. They'll send it to the prosecutor. If they don't comment, they'll come to me. And if I don't have any issues, I will release you early. Even if you haven't paid all the money, because we can still take you off probation, put you on a payment plan for the money. Okay? All right, so looks like that is going to be the complete sentence of the court. Yes, you do. They're gonna have an order for you and you're gonna sign that. And you don't have any money to apply as a bond. Okay. There we go.
Take care.
Thank you.
Ready?
Case number M463497 and B. These are people state of Michigan versus Angelique McCarthy.
Morning, Courtney Rose on behalf of people.
Good morning. Come on, Miss McCarthy. Alrighty, and you are here for a pretrial operating with no license or multiple licenses. It's a misdemeanor, carries up to 90 days in jail, potentially fine of up to $100, not including court costs. And you do have a formal hearing. Actually, it's in default right now on an expired plate on a vehicle, which apparently is in default right now for $140. So you understand what you're here for? And you certainly have a right to have a full trial by judge or by jury with a lawyer on the no license or multiple license charge. If you couldn't afford a lawyer, you'd like to have one, then the court would have someone appointed for you if you're eligible. You understand that? Okay. Did you want to talk to the prosecutor? Probably already did. Did you talk to her already? Okay. All right.
Karen, I was able to have a conversation with Ms. McCarthy this morning regarding the circumstances of this offense. I'm gonna dismiss the ticket, but I'm asking the court if you have resources to please help Ms. McCarthy get her license back. I feel that she's very genuine. She's struggling immensely. She would love to get a valid license, but feels that it's impossible.
We're just in the process of trying to set up an Operation Drive. We haven't done it yet,
I
but
think she'd just be a wonderful person to start that process with.
well,
I'm gonna
let's
dismiss
find
the
out.
ticket today because I don't want to add to her fines and costs and stress. She's got kids, doesn't have a lot of family support. But however, the court can help her, point her in the direction of a new.
I sure can. Let me see. So, okay, now let me tell you first what you got to do. I know it's difficult because you got the kids and you're probably trying to work and you need to be somewhere. You can't mess it up by driving though. Okay. You just did this on Christmas Day. You got to reach out and get your family and your friends and the resources. Now I know, trying to see if there are places where you could get some bus passes or some, I don't know if there's any Uber or Lyft passes because we don't have a program yet. That might be built in to some of that if we have the program. But you got to reach out to some family members and tell them what's going on and that you need to sort of get a schedule and ask. You'd be surprised if you ask and tell them the times who will step up for you to help you at least get to work or get the kids to someplace they need to be. Now, where do you work?
I work at a restaurant, but I still do.
Oh. Okay, so is the West Bloomfield one easier to get to?
A little,
A little bit, because you live in Redford still?
yeah, but my grandmother lives in Southfield, Washington, so.
Okay, so how you getting from the Redford or to Southfield and then Southfield over to the, well, do you know?
They help when they can. I don't have a lot of help.
Okay, well, you gotta make a schedule out and put some time slots in and see who says they could fill what slot. Then you know what your week looks like at least, because you got slots that are filled and slots that are empty. Now, do you have coworkers at your restaurant? Coworkers, people that waitress there, bus boys.
I don't really know my coworkers that well.
Okay, well, you're about to, right?
I've just been working at my new job for like a week.
Okay, but you're about to get to know them. So, some of them are bound to be parents. So you might not have to get to know them too well if they understand that you're a young mother struggling. And then say, look, hey, where do you live? Do you pass through Southfield? Can you get me Southfield if I give you a couple bucks for gas? You'd be surprised. I know if I worked there, I would say yes.
But then even after that, then me and my kids have to get home, so there's always gonna be something.
Okay, listen. You cannot say this.
I'm
if you-
saying it because
I know if that's what it's been. Okay. But now we're about to change it. Our attitude, if you speak it, that's what it's gonna be. So if you speak negativity, it's not gonna happen for you. If you speak the positivity, it will happen for you. That's what you gotta believe. This is going to work out. Okay? Now, when's the last time you prayed for it?
I pray every day, 3 times a day. Pray this morning.
Okay? And what do you pray for?
I pray for everything I can think of to pray for.
No, that's not what you prayed for. If I'm listening, if I'm God and I'm listening, I don't know what that means. I prayed for everything that I could possibly pray for.
That's what I'm telling you right now when I'm talking to God.
Well,
I make a list of things to pray for.
Okay.
It's consistent.
Do you first repent
All the time.
and because we're
My
all,
granddad's a pastor. I know the
yes, okay.
I was raised in the church.
All right, so you repent and you give your thanks.
keep acting like if there's nothing I can do about it.
Okay, well then ask the demons to call these demons around you off in the name of Jesus. Cast them away from you. That's all it is. You know, the devil, if you're God's people, you know the devil comes after you.
I know that, and that's what I'm saying. I just keep getting myself in situations where there is nothing I can do. And it's
Yes, there is something. Where's the father to your children?
at home,
Your home where?
at his house.
Does he pay child support? Did you ever file for it?
No.
Okay, well, there we go. You haven't done everything you could do.
I tried to.
What do you mean you
I
tried?
tried to get a credit card before. They didn't approve me because they said I made too much, but I don't make that.
I didn't ask you about it. I didn't.
I'm telling you, and then that's when they went after him for child support, because when you put your significant other they're gonna come back to the state.
Well, that's because they want him to pay back for any aid you get.
When they would, I don't know whatever happened when they took
Okay,
that,
let me,
but they ended up not putting him on the child support. I can't
okay,
force
what,
it.
no, yes. No, it don't work like that. You can't force the state because the state is looking out for itself. So if they didn't give you aid, they have no basis to get child support from him. You separately, forget the state, have a right to child support yourself. Okay? The state has nothing to do with that. They just get involved if they're paying aid.
Gonna give me,
Oh,
like, wasn't gonna be.
ma'am. So what lawyer, what lawyer, what lawyer are you?
I'm saying this is what I was told.
By who? Who told you?
Some lawyers, the judges,
Some lawyers and the judges.
I don't remember their specific names.
Okay.
In court, like
Joint,
countless times.
people have joint custody all the time and receive child support. Joint custody can be joint legal custody. Okay? It's the physical custody that the child support is specified. So you're telling me so he has the kids all the time too.
We have the kids equal time.
So you don't get any child support because of that, and you filed for it.
Yeah, they told me they're not gonna.
Okay, let me ask you a question. You went down to friend of the court, filled out a petition for child support.
No, they just initially told me they.
Okay.
In child support for either party.
Okay.
Because we had joint custody and everything.
Okay.
That's what I was told, like, knowing the other
Okay.
information than what I'm told.
Okay, I get that, but why won't you go down there and try again?
Because I was told that I don't have.
Okay, so nothing ever changes.
I mean, I don't know what changes. I don't know when things are.
Okay, well, I'm just trying to say, I feel bad for you, but I tell you one thing, you've lost your desire to try. Yes, you have. I just told you to try. You know what you told me? Well, they already told me this, so I'm not gonna go.
Well, I'm telling you why. Previously, you're asking me why didn't I go down?
No, I'm okay.
I'm telling you why I didn't do it.
So you're gonna do it now?
I'm not the type of person who just doesn't care. Won't take.
I didn't say you don't care. I feel you care.
Picture for you, like this is why I haven't gone down there again, because this is what I was told. Now that you're telling me this now, this changes things. I can only go with the information I have. Nobody ever told me that I could after the person told me I couldn't. You go.
People go back and forth on child support a lot.
I know it's the first thing someone told me to go off.
You can change your custody agreement. You can ask for anything.
They re-granted us the joint custody. We were in court like within the last couple of years.
Let me ask you a question. Have you gone to legal aid for any assistance?
Yeah, and I'm trying to get legal aid, and I've been on the waiting list, and no one's ever got back to me. I can't afford a lawyer or anything.
Okay. What legal aid did you go to?
I'm still paying up.
What legal aid did you go to?
I called the office number they gave me, and some office I think it's in Pontiac, the only one they have in Michigan that they gave me. I called legal aid. I looked on Google, looked up all types of legal aids, and they didn't have.
Child, where's the Lakeshore numbers in Southfield? I don't know Pontiac. I don't know what she's talking about.
I think
Ignore the rest of the stuff this is for landlord tenant, but there is a number on there for Lakeshore legal aid. Try that.
was.
But that's not I don't believe that's Pontiac.
Their headquarters are something, I'm not even sure, but Lakeshore Legal Aid is the one I thought.
Okay. So now let me ask you another question. How long do you think you need to work your job before you'll be able to take care of whatever has your license suspended? Because I'm dismissing everything we have here. Let me see what you got. Okay, so it says you're suspended. It says reinstated, unsatisfied judgment. Financial responsibility. Driving compliant. Do you have a car?
We drove it, I don't know how, so now.
Whose car were you driving for this? December 20th.
I'm saying that, no,
You haven't driven it since Christmas, because this is December 25th. All right, let's see. Financial responsibility. Do you have insurance?
no,
Okay. So you definitely don't want to get in an accident, because if you drive and you get an accident,
the financial responsibility insurance is on top of regular insurance that I have to get, on top of paying,
financial responsibility is insurance.
financial ability.
It's not, but it's not on top of regular insurance. That means you just don't have any insurance to drive.
The financial responsibility insurance is basically like,
Okay, you tell me.
I'm trying to get you to understand, it's like, when I was applying previously, they wouldn't let me at the Secretary of State renew anything without, the insurance, but they wouldn't let me just get the financial responsibility insurance.
What do you think?
No, listen, they wouldn't. let me
What
get
are you
driver-
calling financial insurance responsibility?
Financial responsibility insurance for driver? That's the insurance for you to be able to drive.
That's no fault insurance.
I don't think you're understanding what I'm saying.
I'm not.
Financial responsibility is a completely different insurance from low fault insurance. They make me pay that on top of the regular insurance, but that's a completely different, way higher cost than what regular insurance costs. So they won't let me apply for financial responsibility for a driver and take that to the Secretary of State to be able to get the paper that says I can even get regular insurance for the car. They made me get financial responsibility insurance for myself because I couldn't get driver insurance without a license. So then I had to take that back to the insurance place, get regular insurance for my car. And that's on top of that. So it's like 500 or something, then 300 something.
This is the first, I've been doing this. I've been a lawyer for over 40 years and I've never heard of what you're talking about. And I've been a judge for over 20 years and I never heard of that. I could be wrong. I've never heard of that. I've been a driver for over 50 years and I don't pay nothing extra other than the no fault insurance to be able to drive a car. What are you talking about?
Fault insurance for the study that I have to pay.
Right. Now you would have to pay that. You're right.
I'm making payments on that, and then I can't get in contact with the office, so I'm making payments with some office in Ohio, the collection agency. And then, back on, okay, I'm trying to get in contact with you, the last two payments of $100 piece, can I pay 200 now, get it up to date? And he'll say no, and force me to come all the way back to court, and make a court date to get a new payment plan set. So they think that I'm just not trying to pay that, and then I have to get that paid to even do anything at the Secretary of State. Because that's why they won't let me go with no fault insurance. They're making me come with financial responsibility, but I can't get the driver financial responsibility insurance until I have a license to take to the insurance place. So they give me regular financial responsibility for $500, and then I take.
What is regular? I don't even
Then I
know.
have to take it back to get.
Let me ask Ms. Rosenau. Have you ever heard of regular financial responsibility insurance versus driver financial responsibility insurance? I don't know what she's talking about.
The only thing I can think is maybe that personal injury protection that a lot of policies will make you carry if you don't.
Yeah, that's basically part of the no fault law.
There've been a lot of changes to new code in the past few years. I'm by no means an expert.
I've never heard of what she's talking about. But she's got a few things that she does need to take care of. And I'm just trying, I can't tell how much it would cost. One of them is in Royal Oak, no proof of insurance. The suspension.
If there's a no proof of insurance in Royal Oak, that actually might be a godsend because Royal Oak does have the operation drive.
Yeah, but it says suspended, but then it says to August 17th, 2024.
Royal Oak, the reinstatement and everything for all that. That's what I'm
Okay.
saying. There shouldn't even be anything on record.
Oh, what I'm saying is, if you have a matter there, they have lawyers that will help you get your license back for free. They have a wonderful program. And I'm familiar with that program from working there.
And she had financial responsibility and unsatisfied judgment. She got a restricted license in 2023, and it was restricted from July to September. And then it was reinstated September 2023.
Where did you say you were making the payment plan at? Which court?
This court. This for a completely different matter where a lady got in a car accident with me and I didn't have insurance, so I had to pay monthly on that. And when I would get like one payment behind, that's where the guy that I would call in and try to make 2 payments or 3 payments at once.
Well, that's what I was.
He would send me right back here. And every time I come back here, the judge keeps telling me like she told me that it looked like I wasn't trying to pay it, but if I can't afford to pay it, like how am I supposed
So you had an accident?
This was years ago.
Yeah.
That's what the original judgment was for the financial.
You didn't have it?
Financial responsibility insurance on top of regular insurance.
And you didn't,
Yeah. I don't remember the name.
you didn't have any insurance when you had the accident? Is that what you're saying? Is that what you're saying? Because that's what happens typically. The insurance company pays their damages and then they get you and you have to pay it. That's the penalty for not having the insurance. It's not even worth it to drive without the insurance.
This is from years ago, like
I
2018. So this is all stuff that I know now, but there's just nothing I can do about it now. Sorry
Right.
about it. Like
And
I'm
the
literally just trying to fix
of
that
that previous case and
get out of this. Right?
I can look. I don't know if I can find it, but I should be able to look.
I also have some additional information I'd like to share when the court's ready to go off the record.
Yeah, let's see.
Court is on the record in the City of Cognate versus Chelsea R. Lego, case number 26 CRB 15. In this case, Ms. Lego has been charged with a criminal offense. She was arrested as a result on January 21st, earlier today. The court is also going to take up 3 other cases where Ms. Lego has had warrants issued for her arrest as a result of failing to appear for a review hearing on January 15th, 2026 at 1 p.m. Those being 25 TRD 786, 25 PKT 26, 25 TRD 1019. Ms. Lego is appearing at this hearing by way of video from the Cognate City Jail. Ms. Lego, a criminal charge has been filed against you. Have you received a copy of the complaint?
Yes.
I'm going to read you your rights, so please pay attention to the rights I'm about to read to you. You do have a right to be informed of and to understand the nature and the elements of the charge filed against you. You also have a right to know the potential penalties that could be imposed. You are charged with 1 count of obstructing official business. That is a 2nd-degree misdemeanor. If convicted of this offense, you face a maximum 90 days in jail and a maximum fine of $750 plus court costs. Do you understand the maximum potential penalties you face if convicted of this offense?
I do.
Could you speak again?
I do.
Okay. Okay, you have a right to remain silent and not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. You also have a right to a trial to the court, and because you are charged with offenses that carry a possible jail sentence, you also have a right to a jury trial, provided that you timely file with the court a written demand for a jury trial. At trial, you have the right to confront and ask questions of any witness who would testify against you. You also have a right to use the court process to secure the attendance of any witness who you would want to testify on your behalf. At trial, you have the right to be proven guilty beyond a reasonable doubt and a right not to testify. You also have a right to have an attorney represent you in this case. And because you are charged with an offense that carries a possible jail sentence, you do have a right to court-appointed counsel and to have a lawyer assigned to represent you only if you cannot afford one. If you do qualify for court-appointed counsel, there is a $25 application fee and a $50 cost reimbursement assessment that apply. You also have a right to a continuance of this initial appearance hearing in order to retain the services of your own attorney or to consult with your own lawyer. If you are convicted of this offense or any related offense, you have a right to appeal the conviction or sentence. That must be done within 30 days of the conviction, and you would be entitled to a court-appointed attorney in the Court of Appeals if you receive a jail sentence and cannot afford a lawyer. Now, if you plead not guilty today to this charge, I will set your case for further proceedings after today, and I will set a bond. A bond is set by the court to ensure your appearance at all future proceedings, as well as to protect public safety. And today you have the right to a reasonable bond. If you are not a citizen of the United States, you are hereby advised that conviction of the offense to which you could be pleading guilty or no contest may have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. Now, Ms. Lego, you have 3 plea options available to you with respect to this charge. You can either plead guilty, not guilty, or no contest. If you plead guilty, that is a complete admission by you to the offense charged. If you plead guilty, the court will find you guilty, and then I will impose sentence. The second option is you can plead not guilty. If you plead not guilty, that is a denial by you to the offense charged. And as I said earlier, if you plead not guilty, I'll set your case for further proceedings after today, and I will set a bond. The third option is you can plead no contest. If you plead no contest, that is not an admission of your guilt, but it is an admission by you of the truth of the facts alleged in the complaint filed against you. If you enter a plea of no contest, this court will find you guilty, and I will impose sentence without any evidence being presented against you. However, the plea of no contest cannot be used against you in any later civil or criminal proceeding. Ms. Lego, do you have any questions regarding the rights or the plea options I just explained to you?
No.
Okay, so with respect to this charge of obstructing official business, a second-degree misdemeanor, how do you plead?
Guilty.
You understand, Ms. Lego, by pleading guilty to this charge, you are waiving your right to a trial, which includes your right to cross-examine witnesses and to confront evidence presented against you. You'd be waiving your right to testify or not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses. You'd be waiving your right to a jury trial. You'd be waiving your right to be proven guilty beyond a reasonable doubt. All of those are trial rights you'd be waiving by pleading guilty to this charge. Is that what you wish to do?
I mean, I kind of wasn't wrong. No.
Okay, but you've entered a guilty plea, and I want to make sure you understand by pleading guilty that you're waiving all of those trial rights I just explained to you.
Yeah.
Okay, also by pleading guilty, you would be waiving your right to an attorney. You do have a right to have an attorney represent and advise you in this case. By pleading guilty, you would be waiving your right to an attorney. Is that what you wish to do?
I don't know. I don't know.
Okay. I'm going to. I see some great hesitation in the defendant. I'm going to enter no plea on the defendant's behalf to this charge.
I mean, I was technically.
I don't want you to say anything that might incriminate yourself. I'm just when I see hesitation by defendants like yourself, meaning they don't understand or they don't know what to do, I'm going to enter no plea. In this case, we'll have to proceed further. Okay. Do you wish me to consider appointing an attorney to represent you?
Sure. Yes.
Okay. Do you have any source of income?
Right now, no. I mean, I was working
When's the last time you worked?
a couple days ago. I've been cleaning houses. I just got a new house, so
So you do it. You're kind of like self-employed.
yeah.
Okay. How much on average do you make a week?
Well, I recently just started, so anywhere from $800 to $1,000.
A week?
Yeah, give or take.
How long?
I was taking care of more stalls too, so
I'm
my
sorry?
neighbor.
Say that again.
My neighbor has 4 stalls that I've been cleaning out.
How long have you been doing this?
Quite a few weeks.
So you've been getting on average $800 to $1,000 per.
That's the most I've made so far. Was
Okay.
about $800.
What on average? What do you make a week?
I don't know. Like I said, I just started, so let's say between $400 and $800.
Do you support anyone financially besides yourself?
My kids,
How many children?
I have 3.
Do they live with you?
They've been living with my mom, but I've helped her take care of them. I was in the process of getting them back.
Okay, I'm gonna make a finding that she does, based on what she just told me, she does qualify for court-appointed counsel, and I will appoint the public defender's office to represent her. Now I'm going to address the issue of bond. Where do you live, Ms. Lego?
Between 280 Center Street, which is where my mom lives, and 7328 Harmon Road. Also Cognate.
So your mom lives on Center Street. Who lives in Harmon Road?
I do.
Who do you live there with?
Myself.
Do you rent the place or do you own it?
It was bought for me.
So if that's your home, why do you go between?
Because my children live with my mom, so I go over there. It's where you can find me. There's 2 places you can find me.
So help me understand, why did you fail to come to court again on
Because I never,
January 15th? Excuse me?
I never received it. You guys have the wrong address. You guys have 480 Center Street. This is the second time I've missed court because you guys sent me the wrong people.
Ms. Lego, let me explain something to you. I have in the files a signed receipt. When you were last in court, you signed a receipt. And I'll give you the date. You signed it on December 10th, 2025, and it gave you written notice of the hearing on January 15th, 2026 at 1 p.m. We didn't mail anything to anyone. We gave you notice in person on December 10th. So why weren't you here on January 15th?
I've had multiple court dates for stuff that happened years ago in Ashtabula. I've been overly worked, overly stressed. I've been dealing with things at home with my 11-year-old son. I didn't realize. I was thinking that it was towards the end, more towards the end of the month. For some reason, I was thinking it was like the 30th. I had no idea it was the 16th, or I would have at least called and to reschedule something. I had no idea.
You did have an idea. We gave
I
you
did
notice.
a whole month ago.
Yeah.
I've been dealing with a lot. A lot. My son is 11 and he's going through a lot of stuff. That's a whole different situation. I would have never missed. I would have never missed.
The law director has submitted a bond recommendation asking the bond be set in the amount of $10,000 personal recognizance, alleging that on January 21st, 2026, in the bond recommendation, I think that's a wrong date, it's actually January 20th, 2026, that the defendant interfered with officers trying to conduct a traffic stop near the defendant's residence.
I simply asked them.
Be quiet. I'm not asking you to speak. Are you receiving any treatment services for substance abuse or mental health?
No. I should probably see a counselor for mental, though. My son's going through a lot of shit.
Okay. So, have you ever received treatment for substance abuse or mental health?
I've received counseling, yeah.
Where
in the
at?
past.
Which agency?
Been a while. In Ashtabula, Signature Health.
Ms. Lego, let me make something really clear to you. Because we're not freaking messing around. And you shut up and you listen. If you fail to come to court again, listen to me. If you fail to come to court again, like you have repeatedly done, if you fail to come to court again, and I issue a warrant, and you will be arrested on that warrant, you won't get out. Do you hear me?
I understand.
Because I've had it up to here with you on traffic-related cases. This is the first case you've had a jailable offense. Your cases drag on and drag on and drag on because you fail to come to court. And I can't believe that I'm going to follow the prosecutor's recommendation here. However, there are conditions to your bond, so pay attention. $10,000 personal recognizance. You're ordered not to consume or possess alcohol or drugs. You are subject to random chemical testing by probation and law enforcement. You are to undergo an alcohol drug assessment at Signature Health, and you are ordered to comply with any recommended course of treatment. I am ordering that you undergo a urine drug screen today. You will not be released until you submit to a urine drug screen today. We will set this case for a pretrial conference in the near future when the prosecutor and your public defender are present. I will lift the warrants that were issued in all of the traffic cases, and I will set all of those cases for a review hearing on the same date and time as the pretrial conference in this case. Don't mess with me, Ms. Lego. Don't mess with me. You better be here when you're supposed to be here. Whatever calendar or calendars you have, the date and time that will be given to you for the next hearing before you're released, get it on your calendar. And then stop blaming everyone else for not being where you're supposed to be. Understood? Okay, this matter's concluded. Thank you. Thank you, officer.
You're welcome.
Town Center Place versus Sigrid. Can you hear me?
Yeah.
Okay, fantastic. All right, I've called all three of these cases, and
Good morning, Judge. Mark Glassberry for plaintiff.
All right. State your name.
Mike Melman.
Okay. Your name.
Secret Melman.
Thank you. All right.
Judge, when we were last here in December, I think the stage was set to discuss a conditional dismissal.
Yes.
I do have, I would propose the standard scale form CD with an addendum.
Okay.
And I have an addendum that I'd like the court to look at, and I'm presenting that to Ms. Melvin and her son.
Can you place it a little bigger so I can see it?
Okay. I see what you're saying. Is there a bigger, or do you want us to blow it up? Can you see it or no?
Well, I forced myself.
Okay.
Defendant agrees to do the following. Complain with pest control and properly just. Huh?
Why don't I do this? Let me pass this briefly, let you go out. You can use one of the conference rooms and read that to her and make sure she understands it. They're right outside the doors to the side. All right, quarter past these matters. Fixing housing 401k plan versus Erica Ward and Aaron Ward.
I don't know how to this. All right.
Who is that?
Good morning.
Good morning.
John, I'm not sure about that case. Good morning, Your Honor. Steve Etherby on behalf of Plaintiff Fixing Housing, 401k.
Erica Ward.
Aaron Ward.
Thank you. You may be seated. Folks, you were trying to figure out your case?
I'm just asking a question. I requested our arrest thing. Do I have to stay in here? Or?
Oh, bless your heart. No, we're adjourned out.
Okay.
And-
So that's why I was here. I requested our arrest.
Okay. Are you still, let me just ask you this. What's your name?
I'm still living in our arrest. I'm part of our arrest.
Okay, so you're still there. Okay. Have you been dealing with the tenants union and?
I've been talking with them guys.
Okay, so what I would suggest you do, because Arbor West falls into a sort of a different category than the ones that have to be vacated. I think that's what they were telling me.
That's what I talked with him like about a week ago.
Okay, so I guess if you don't have to remain here. If you have any questions, then you need to direct it to them. Did you post any money, just out of curiosity, did you post any money into our escrow account? You did not. Okay. All right. Very good. Okay. Thanks, guys. Okay, folks, where are we on this case?
Your Honor, we're here for our 7th hearing in this matter. If you recall.
And you might be to 10 by the time you guys get done, but go ahead.
But at the last hearing, we had our motion. It was a motion hearing.
Yes.
And you stopped it and it essentially became a settlement conference.
Yes.
Nothing came out of that. It didn't settle that day. How about that? After that hearing, the tenants sent 2 notices of repairs, which one of them matches one of the pending motions that's before you. Our response to that motion would apply to the second notice of repairs. And Your Honor, also, I learned on Friday afternoon, I received an email from Touppe with the filed correction of defendant's response to plaintiff's motion for summary disposition that was filed on their behalf.
You received what?
I received an email from Donna Toupe with what appears to be, and it's a filing. It's called Correction of Defendant's Response to Plaintiff's Motion for Summary Disposition that was filed on their behalf.
Is it in here? I did not. That was on Friday you received it?
I received that on Friday afternoon. And Ms. Toupe.
No, I got there.
I may be able to.
Hold on 1 second.
Your Honor, I also have the email from Ms. Toupe, which it appears like she's still representing.
I don't.
Oh, there it is.
January 14th. They just threw it in the file. All right. Okay. I did not get a judge's copy of it, but I'm just. So. Okay, go ahead. I scanned it, but it's basically her affidavit, it looks like.
Your Honor, it appears to be a supplemental corrected affidavit by Ms. Toupe. It's blamed on a computer glitch from the previous affidavit that she filed in response to landlord's MSD. I have many problems with the filing. At December 19th hearing, you ordered a moratorium on plaintiff's motion or party's motion practice, and it does not appear that they asked you for leave to file this corrected response to our MSD. Toupe filed this on behalf of the wards, even though she was required to withdraw from this case, and she did withdraw from this case. Toupe's filing in her email, which again, I have the email, which demanded a copy of landlord's MSD. So it appears that she's still acting as counsel on behalf of the tenants. And tenants are responsible for their filings. They can't plead ignorance to this. The filing and Toupe's affidavit are dated January 8th. That's 2 days after our last hearing. The proof of service falsely states that it was filed with the court and served on landlord on January 8th. The court stamp shows that it was actually filed on January 14th. And again, I didn't receive a copy of this filing until Friday afternoon, right before MLK holiday. Your Honor, I can address the substance of this corrected affidavit. It appears that she's still making the same residential lease argument that, as you recall, Your Honor, you warned the tenants that if they continue to make this argument that they could be subject to sanctions. They made the argument and they continue making the argument.
Let's deal procedurally, I guess, before I get to the substance of it.
I can address the substance.
So, well, yeah, I know you can, but I want to try to figure out why this is here.
Okay.
You want me to address that?
Yeah, please.
I had no idea as to procedurally. All I did when we left is said, your affidavit was like glitched, incorrect, you've got stuff. And so I didn't ask her to do anything. She's not representing us. She just said, hey, just so you know, I fixed my affidavit. And that's as a witness, not as a lawyer. So what she says in her affidavit as a witness, I I didn't have anything to do with it, and I didn't even realize it would be an issue. I told her that her affidavit was not correct at all, and that is how she followed up. She is not representing us, Your Honor.
This doesn't make much sense to me as to why she did this. She's not here to answer.
I have the email, which it appears that she's still acting on your behalf in this case.
Hold on a second. Can you show, were they CC'd on that, do you know? Or can you show them, and then I want to see the email? Where's, oh my goodness.
That's fun.
I don't think it's a refiling, I just think it's a refiling of the original one with the correct affidavit. So I don't know
Okay.
the specifics of the law, but to me, it just looks like a corrected, something that she had already filed. Actually, correction to what we filed.
Mr. Ward, I guess it would be one thing if you had filed something saying, here's the corrected affidavit. And if you went to Ms. Toupe and said, this is all wrong, here's the corrected affidavit, and you guys sign off and you file. That's one thing. This is a whole other thing along when you take it in the context of that email. I don't know why she's still communicating with counsel. It doesn't make any sense to me.
I did not ask her to do that at all. And I understand what you're saying. It would have made sense for her to correct her affidavit and hand it to us so that we could submit it. I have no idea why she did that.
So here's where we get into another thing. She filed this without your permission.
Yes. Believe me,
Have you
staying as far away from
have,
Toupe as possible.
did you read the affidavit?
The initial one.
No, I understand the initial one. Did you read this doc?
No, actually, I didn't. I did not.
I did not know.
Updated, I mean, because I didn't even realize that initially when we submitted it, that we submitted something that had pages mixed up.
Your Honor, they're still responsible for their filings.
Yeah, but I don't know if that's their filing.
She mentioned about the pages being mixed up. Their response to our MSD, they are still responsible for their filings. That's all.
No, I understand that, but I don't know how I hold them responsible for things that were filed without their knowledge, is what they're telling me. That's the difficulty I'm having, right? Is that procedurally, if Miss Toupe came along and filed this, but had gone to them and said, here, this is, I see what you're saying, so I need to correct this. Here's this, I'm going to file this. That might be one thing, but that's not what I'm hearing here. I'm hearing that this was filed. You guys didn't have any knowledge as to its contents.
Correct. I did know that she corrected it after the fact and submitted it after she did it. I had no idea any implications that would come of that.
You had
I hear
knowledge
now
that she
that
did, that she did what?
That she fixed it after the fact, but she never told me that she was.
What does that mean? That you had knowledge that she fixed it after the fact?
She told me she did it after she sent it to them, but it was already done. She never asked me if she could do it.
So after, when was that?
At some point after they received it.
Well, they just got it.
We received it Friday afternoon. Even though it's dated on there January 8th.
Yeah, I would have to look. I don't know.
You have to look at what?
My email.
Look at your email. I want to know. Need 14 days for an order for the house.
Actually, there's nothing in here, so she must have just told me that she would fix it. If this is any help in understanding my brain frazzle, I also have a case of strangles at the farm.
What?
If this helps you understand my brain frazzle, I also have a case of strangles at the farm.
Okay.
Your Honor, I would add in the context that Ms. Toupe is still representing them in the circuit court action.
Yes.
My understanding was that we were here today to continue settlement talks and that the settlement that we presented on the 6th was rejected.
Right.
Okay.
We might be. And I may have called the parties back and said, look, where are we? I mean, counsel kind of let me know where his claim, but the problem I'm having and what is creating a bit of a difficulty here is that there are documents that are being filed in this action, not by you.
Nor with my permission. I don't know how I.
I don't know, 10, 14.
14.
It's 14 exact.
Yes.
Was there anything recently filed in the circuit court action, counsel?
No, Your Honor. Yes, our witness list, yes.
Right, okay, but I mean, anything else by Ms. Toupe that was,
I filed my witness list and then she filed her witness list hours after.
after, got it.
I can find that date. But to my knowledge, Ms. Toupe is still representing the wards in the circuit court action. And it seems like they were still having communication in this case.
Yeah, and the communication I don't necessarily have a problem with. What I have because I don't know that I could stop that in any event, but what I do have a problem with, so things are filed before this court, presumably on your behalf, but without your knowledge. That just it. And then counsel has to spend time looking at it and trying to respond to something that you guys didn't file. And you don't even know what it is at this point.
Today?
I don't think either one of them said they've seen it before today. Did you see it, ma'am?
We talked about it, that she was updating it, but neither one of us read it.
No. I get that there can be these conversations,
Yes.
right? I mean, and I don't have a problem that she was going to update whatever.
Right.
Have you
No.
seen what was filed in court on your behalf?
No.
Do you know where Miss Toupe is right now? Because I'm going to tell you, I'm a bit livid, just a bit.
Can you take that up with her?
Well,
I'm trying to keep
I
it out of it.
intend, no, I intend to, but here's the problem. Yes, I don't think the parties, and I'll just say this on the record, I don't think the parties were all that far apart in terms of how this matter could be resolved. That's just this court's view. But I also have these motions before me that I need to rule on. But at each, and so we come back here, regardless of what the parties thought may happen, might not, whatever, right? She then interjects herself, and quite frankly, interjects herself in a way that for an attorney to do it, for anybody to do it is a bit appalling. For an attorney to do it is tenfold that. Because in effect, let's look at it this way. If Ms. Toupe were representing you, she shouldn't be filing anything with the court that you have not reviewed or she has not gone through with you and you have not seen. But she's now filed something not as the attorney on your behalf, and you have no idea what it is.
I understand. I should have taken her affidavit and had Aaron submit it. That's a correction.
But I'm not going to tell you what you should do because I mean, I haven't looked closely at what she submitted vis-a-vis the other part, but you can't respond to her affidavit.
As a witness, I thought, because she was a witness to the
No, but the affidavit is submitted as part of a motion for summary disposition. So if we go forward with the motion for summary disposition, you don't know what that says. Right?
Right. I mean, I have a general idea but no, specifically, no.
You don't know what it says.
Correct.
The only general idea you may have is what Miss Toupe in the moment told you she was going to do. But you don't know what it says, do you?
No, not specifically.
So if I have counsel respond to the substance of this affidavit, I just want to be clear. You can't respond to the substance of what's been filed.
Okay.
No, I mean, that was a question.
Oh, I cannot give you the specifics of the substance of what was filed, other than it was the affidavit, and I know in general, as a boarder, what happened with her horse and the injuries sustained due to the fencing. And the witness that she is to the collapsing buildings and the fallen trees and the heavy equipment.
But this is wasting the court's
Yeah,
time,
I don't-
and it's wasting plaintiff's time.
I don't need to,
What?
I don't need to talk about it. I thought you were asking me.
Well, the problem is maybe I'm a bit unclear. Counsel receives this on Friday. That requires him to do certain things, increasing the cost to his client. He comes here and then has to spend time in this courtroom making an argument regarding something that you don't know anything about, but are connected enough to the person that filed something on your behalf. That's a problem.
Your Honor, I would just also add, this has been a pattern. We've had hearings set and tenants file motions and send them to me 2 days before the hearing. This is a pattern.
No, I get it. I get that part of it. And most of that stuff we can sort through, but when that was happening,
I think we got the motion for summary judgment the day we were coming in here. No?
well, you may have gotten it, but I think somebody.
Yeah, and the file, it wasn't noticed for the same day.
I'm gonna let you go ahead and argue your motion. All right, go ahead.
Your Honor, would you like me to address the affidavit?
Yeah, I knew we were gonna get there. Yeah, I'm gonna let you do your motion. It's a fair question as to whether or not.
Your Honor,
Hang on a second. Court's gonna stand in brief recess.
All right, County Washington State of Michigan, is now back in session. The Honorable Judge K.
You may be seated. Back in the case of fixed housing, 401k plan versus the wards. Here's what I'm going to do, much to your dismay, because I'm going to give you an 8th date. Okay. An 8th date to come back, an 8th time. But I am adjourning the motions for summary disposition. I am also, after some consultation as to some of the ethics that have been involved, which is why I was taking the rather prolonged break, that I'm going to set an order to show cause for Donna Toupe to show cause why she should not be held in contempt for the filing of this. I would just place Ms. Ward, I would place you on notice that you have made a specific representation to this court that you had no knowledge of any of that. And so I'm holding to that representation in terms of setting this notice or setting this order to show cause. Counsel for the plaintiff, in the event that the court would award sanctions and or costs, I would need a billing from you, an appropriate billing from you, laying out from certainly the time Friday, time that you received this, what you had to put in to do that, and your work up to that, as well as what other stuff you may have to deal with this being adjourned out 2 weeks to that day. I will then adjourn it for the motions and for the order to show cause to February 3rd at, you wanted me at 2
p.m.
At 2 p.m.
Can I hear again what those two purposes are?
One of the motions that I'd like to rule on at some point, but the other is for an order to show cause as to why Ms. Toupe should not be held in contempt of court and or sanctioned.
On that second note, how does that have anything to do with me and?
Oh, it certainly does, because here's going to be part of your problem, as it may be, and that is I will have to make a determination if Ms. Toupe gets here and says that that was filed with your full knowledge and authority because you have represented to the contrary. And so I would suspect that when the two of you get here, you're going to be very much at odds.
So you're going to reach out to her separately, though I don't have.
Oh, no. Yeah, we will be sending a little piece of paper commanding her to be here.
But has. Wait. Okay. Can I ask one question before you adjourn today?
Yes, ma'am.
Plaintiff's lawyer mentioned that I had reached out with 2 additional complaints, and I just need to understand what my legal process moving forward would be when I have a fence fall over or don't have water, because those weren't additional complaints from the past. Like, I'm still there.
You can certainly reach out with whatever, right. You can reach out with whatever repairs. I certainly would have been in a position to kind of address that today, but I
realize that my landlord is probably not, as usual, going to do anything about it, but I want it documented that, hey, on this day, the wind blew this section of fencing over. It just keeps happening. So that's okay to email him.
You can email him.
Okay.
As long as it's you emailing him.
Yeah, it's no motions or anything.
All right.
Thank you, Your Honor.
Sir, was there anything else?
I would just say when you email me, put that it's for this action because Donna Toupe is still representing you in the circuit court action. So be clear what you're talking about. Because there are two actions.
So regarding my lease, these things are falling over. Is that correct?
I think what he's trying to say is that you are directing your concern regarding this case,
right,
as opposed to the case that you are represented by Ms. Toupe.
No,
because presumably, so listen to what I'm saying. That it's regarding this case because presumably if the complaint were to be in that other case, he would be receiving a communication from Ms. Toupe.
Okay.
I'm trying to.
And yeah, right. Because he can't respond to you in a case in which you are represented by an attorney. So you have to make it clear that this is the case you're dealing with.
Okay.
All right, folks. Thank you.
Thank you.
And so that, I guess one other thing, I was not aware of that filing because it had gotten put into the file and there was no judge's copy that was presented to the court. So it did not come to me. But. This is my last line. All right. Hold on. Center Place versus Sigrid Melman. Okay. See? Go. All right, the parties are present once again. My understanding is what? That. Can you hear me now, Ms. Melman?
Okay.
Okay, very good. Okay, so my understanding is there was going to be a conditional order of dismissal with these terms, right? Ms. Melman, did you get a chance to go over all of the terms on here?
Yes, we did.
Okay. You have any issues with any of the terms on there?
Yes, quite a few.
Oh, boy.
I talked with their attorney down through the items, and we've had our discussion and I've come to an understanding.
As to,
Agreement on the dismissal.
pardon?
Agreeing on the dismissal.
On a conditional order and dismissal?
Yeah.
Okay. But these are the terms under that conditional order dismissal. Is that correct?
Yes, we're going to just add a few words in on 1 or 2.
Right, so.
Okay. Go ahead.
About halfway down, so outdoor planting boxes are a courtesy, etc. They've become overgrown, my client will remove overgrown.
Okay.
And I want to add to that, I'll add it to my copy right here, after reasonable notice to.
Okay.
Where vegetables and ferns grow tall.
Yeah.
I'd like to see something along.
And so, Judge, some of the plantings are not flowers, maybe they're not pretty, but we're concerned about weeds and things that
Correct.
get us in trouble when we have a hot inspection.
Okay.
My turn.
Hold on. What was the other thing? Was there another change of language?
Mr. Melvin, what else would you like? We talked about everything. There was some.
That's pretty much it. I was just concerned, some are like fennel grows 6 feet tall.
Exactly.
It needs to be, they took it out of the box and on the whack. Cut over cardboard. And then all your answers, answer all your questions until you had lunch. Trust me.
Oh, okay. Yeah.
All right. Was there anything else in that regard? Okay, yes.
I just have one question. Since it's not on a court ordered paper, how legal is this? Because it's only
Okay.
14 And doesn't have the case number.
It will, because there are other parts of that document in terms of a conditional order of dismissal.
Oh, okay.
Okay, and so basically what will happen is the case will be dismissed conditionally.
Good.
Okay, as long as, and you're doing it under all three case numbers, or
Can I put all three in the?
that'd be fine.
And I told Mr. Melman, I will show this to him in the standard scale form.
All right, and it's a standard form. Or is it going to be a 4A or 4B case? Are they going to be entitled to a hearing?
I'll leave that at the discretion of the court.
I think it should be she should have the right to a hearing, notice of hearing. All right. Okay, Ms. Melvin, you understand that? So the case is dismissed at this point, but it's conditional.
Okay.
So as long as you follow all of these rules, okay, you can do it. I know you can. All right, as long as you follow all of those rules, then the case just stays dismissed. Hold on, if there becomes a problem, then they've got to give you notice of what the problem is. Then you get to come back and see me.
Okay.
We like you.
Now, I've been in that building since 2006.
You know what? I know that because you tell me that every time you come here and see me.
Oh, okay.
I know how long you've been there. I almost feel like I've walked through your tenancy with you.
Okay, I'm thankful for that.
Yeah, all right. So you follow these and do that. And so come this spring, when it's time for plants, just make sure that you have the right number of pots out on your balcony. Remember, and the other thing is no hanging from the top.
Yeah, not even the American flag. Isn't that nice?
I don't know about that. I was only dealing with plants. I'm not, Ms. Mel, you are not going to lead me down that path. All right. But no hanging pots can go up on that. Okay.
Well, we'll see. Okay.
Okay.
Judge, the 3-day rule,
Yes, I will apprise him of that momentarily.
I'll check that.
Yes. All right.
Sign this. Sign the addendum also, just,
Yes.
presented to. This is the official court form. And this is where the defendant signs and dates. The substance of our agreement is right here.
Oh, look.
And I signed it, you could also sign it.
Oh, that's a court order. Okay, thank you for the correction.
Here's the case number.
Okay, that's fine. No, it's just, oh, it sounds like, okay.
You're done.
Okay, yeah. Okay.
Conditions. Okay. Now, this is the last page. Sign here. This is his signature. Get a substance. Sign that. Okay, got it.
What do you want to sign?
Oh.
Hey, Dutch, you want to hear something funny?
Okay.
Since they're stalking me all over, guess what? They even follow me into my bathroom. Because when I flush the toilet, they know about it because the toilet comes on every 2 seconds. So they stalking me.
They're stalking you. Okay. Maybe they'll stop that. Okay. I gotta tell you one other thing. Okay.
Yeah.
Okay. That I'm gonna sign this. Well, first of all, I'm gonna ask you, you got any questions regarding any of this?
I got a lot of questions.
Well, do you really?
Like the one that says I called the fire department.
We had a conversation about that.
Oh, well, does the judge know that?
Both instances were resolved by the door motor being replaced, wiring in the wall, the fan in the bathroom that was smoking blows sparks out. That motor was also replaced.
Okay.
I did go over to the fire department, talk to the whole fire marshal, and I asked them, I explained what happened, and he said they had no problems or issues, as far as her, creating a felon or,
Great. Okay.
unwarranted calls.
Okay. All right. Very good. Okay. So,
Yeah, I had a flood from the first floor coming down. It flooded my front door, the back door, the hallway to the bathroom.
okay.
No help came from the office. They wouldn't even let me have the vacuum cleaner to suck up the water.
Okay. Well, maybe, Ms. Melman,
I
maybe,
know what to do.
right. It'll get better. Okay. So if those are the questions that you have, now the next thing is, I do have to apprise you of this. You have 3 business days from the time that I signed this to think about it. If you think that there's some mistake that you made, some confusion you have regarding this, or some right you did not assert, you would have to file a motion with the court within that time frame.
3 days?
3 business days.
Okay.
Okay, but you understand that even if you do that, that doesn't mean that I would set this aside. I would hear you, but it doesn't mean that I wouldn't then end up just denying that and hold you to this. You understand that?
Okay, do you understand that?
Yes.
Yeah, okay, sorry.
You understand? No, it's okay. It's okay.
Thank heaven for my son.
Yes. Yes, indeed. I think he has been very helpful to you in terms of trying to get this resolved.
Because all the agencies I called, no fair housing Virginia. But the 2 ladies were here, but they never got to talk.
Well, listen, here's the thing. I don't know if you remember this, but you told me one of the first proceedings that you had a son. And you kept telling me, you were saying very proud things about him, but you didn't want to bother him too much about it.
No.
And I kept trying to encourage you. I had a feeling. I don't know your son, or didn't at that time, certainly. I just had a feeling that if you called him, he was going to be there to try to help you out. And
He's been here around my house for the last 2 months.
yep,
He's even taking time off from work to help all this stuff.
She didn't call
Yeah.
yeah, it's true. She
me.
did.
The lady from,
Oh, that's right.
She's the one that called me.
Yeah.
Yes, I went over with a bunch of people and had storage containers. No, what we're gonna do is put everything she had in storage containers and stack it up.
Right.
You see the difference after I got the books out.
Yeah.
And yeah,
Well, however you got there, thank you for stepping in.
Well,
Okay. Appreciate it.
I have thinking back how I got into this position. Well, I contacted nonprofit LSSCM.
Legal services.
And we had an interview in the office with a lawyer, came on. They never explained what was happening. So next thing I know, I'm at my doctor's office and the social worker there asked me to come to this room and watch this on Zoom. So I don't know how it went from there. Then I had a knock on my door, Labor Day. The young lady said she's from the state of Michigan and she's just gonna come see if I'm okay or something. Well, the next thing I know, it's the state of Michigan and 4 people
and the federal marshal to move my stuff. What the hell did I do?
You know what? I understand it causes you great frustration and just hold on a minute, okay? But out of all of that, sometimes there's a great blessing and great joy. And I can tell you for me, this case has been kind of tough trying to figure out everything, counting flower pots, doing all that stuff off a balcony and all of those things. But one of the blessings and great joy is I got to see my good friend, the attorney here on this side. But also the great blessing is that I got to meet you.
I lost 30 pounds and my blood pressure is 100 over 200. So I'm very fortunate here.
Yes. And so I will always consider that a blessing, Miss Melvin. All right.
I'm 84 and I'm going to be a great grandmother in the next 2 weeks.
Are you? Well,
Yeah.
Congratulations.
Heaven loves me.
Yes, indeed. And you don't look 84. I would have pictured maybe 29. All right. You guys take care.
One more question.
Yes, sir. Yes, ma'am.
For the motion, when do I pick up the phone at the desk?
You don't need to file that motion. You just have the right to do it.
Oh.
I don't think, I mean, you can do it if you want, but I don't think that you need to, given how this is all worked out.
Okay.
All right?
Thank you.
You're welcome. You take care of yourself.
I bet nobody else will.
Thank you for your patience.
Not a problem, sir. Thank you. Mr. Rosberry, thank you, sir.
Oh. I'm wondering what was wrong. Thank you.
Thank you. So copies will be mailed?
I sent them out. Yes, they should be mailed out to you.
Okay, thank you.
All right, thank you.
Mr. Walker, let's come on up, sir. Thank you for waiting.
Good morning, Judge.
Good morning to you, sir. Thank you for waiting. We had these other matters that were fires that we had to fight, that we needed to deal with, and thank you for being patient.
Yes, sir.
On this case, this is cause number 14-19966. The state of Texas versus Calvin Gary Walker. Mr. Walker was placed on probation. That probation was revoked. He has appealed the revocation of that matter, and we are awaiting the disposition from the Court of Appeals on that. Meanwhile, he was granted a bond on the appeal, essentially for the purposes of repaying the restitution that was owed based upon the jury decision and the court's determinations. And what I want to know is where we are on all of that. The last time we had a hearing, we ordered the disposition of properties to be transferred over to the Beaumont Independent School District that the defendant had owned. And I want to know what the status is on that. I haven't heard anything. I haven't heard anything one way or the other. But I want to make sure that all the transition of the properties were going into the Beaumont Independent School District coffers, and for the people, the taxpayers, to be relieved of some of this indebtedness. And also, what is the status of Mr. Walker's
payments toward restitution, which was the major reason that the court allowed a bond on his appeal. And where are those? That's what I'm curious. From probation, can you please, Ms. Hunter, give us an update on all of this? I have something dated January 21st.
Yes.
That you've sent, and has the defense gotten a copy of this? No.
No, I'm sorry, Judge. I didn't know if you were asking me.
Yeah.
I've sent I have a budget sheet that Mr. Walker filled out. I don't know if that's what you're referring to.
No, this is what I'm referring to as
No, sir.
notice. Okay, let me make a copy.
Or email it to him.
Okay, we're gonna get this over to you right now. What it shows is, it looks as though restitution, the defendant has paid over $12,000 to the Beaumont Independent School District so far. That is not including the real properties.
No, sir, it's not
That
included.
have been ordered, transferred, and that's what this part of the report that you're about to get.
Okay.
It shows a financial determination, and I'm just sending you the cover a page. I'll get the other. It looks like 5 supplemental pages, which consist of the defendant's payments that are made to the probation office since his supervision began.
And I had seen that probably not updated for the last 2 months, I'm guessing, Judge, before our last setting.
Yeah, this is dated January 21st, 2 days ago.
Okay.
So, yeah, but
Did you want a status on the appeal while we're waiting for that email, Judge?
I do.
Sure.
Yeah.
I'm gonna I can get you the exact dates if you need, but about 50 days ago, I filed the appellate brief. The state's was due end of December. They did request a 30-day continuance. Their due date should be coming up in the near future. I'm not really positive who's handling the appeal for the state. I'm guessing they're not in there with you, Judge, but their due date should be around February 1st. And then as far as the property, we were also wondering, I think last time we were here, we had a monetary amount we assigned, which was the tax valuations, and we didn't know how that was going to get credited either. So it sounds like you're already looking into that.
So what do we know from the state on that? Anything?
Judge, I apologize.
No, you're Ms. Nealand.
Angela Nealand is handling the appeal. It's actually being finished up today. It should be filed at the beginning of next week for purposes of informing him.
You come on up, so yeah, he can.
Sorry. Again, I apologize.
No, you do us the honor.
Angela Nealand's handling the appeal. That'll be finished today and filed early next week. And obviously, it covers a myriad of issues that they've raised, including the property, the original revocation, a bunch of different issues, of course. And all of that is working its way through the system. So obviously, we have a concern that we don't want to do anything to disrupt the appeals process. But as far as the property valuation, we haven't really been involved in that because obviously we were opposed from the beginning, but I know he signed over some things. We later discovered after the hearing, there was a quite substantial tax delinquent bill attached to those. But again, we're not involved in that. I don't have any information with regards to that because we haven't looked into it or been part of that.
Thank you. Well, that's going to, I don't know how we're going to resolve it, but it's got to be resolved somehow. But the Beaumont Independent School District their leadership has always stated they want to recover all that they can from Mr. Walker on his obligations that were dealt with in this trial. And so the court is running out of assets of the defendant to turn over. And that those two properties, if there are tax consequences, those are going to have to be dealt with, and that's going to have to be resolved to net what is going to be determined. That will be transferred over in monetary value to BISD. What's being done about that? I don't think I'm supposed to do it, but what are we supposed to do?
So, Judge, from Mr. Walker and my perspective, we signed the quitclaim deeds. I stuck around, made sure they got filed with the proper clerks, and I think you actually helped me out with that. So I can't remember what the issue was, Judge, but we got those filed. I don't think that he owns the properties anymore. And so if anything else is needed to transfer those, let us know. But my understanding is, BISD owns those properties. I think it's 3 properties now. I mean, that's what
Yeah,
I'm not a property lawyer, but I remember from law school, I think a quitclaim deed transfer that to BISD just as you had asked for, Judge.
Okay. Well, he will obviously be given whatever credit if there's tax indebtedness. I've never figured a way to prioritize over the tax man. I don't know how that is supposed to work, if it's possible, but taxes are going to have to be excised out of that value. And then whatever the remaining value is, the court will intend to give fair credit toward Mr. Walker's obligation. And if there's an issue on that, we'll resolve it.
Okay.
Y'all about it. But I haven't heard anything yet myself about what has been done in taking the tax obligations, if they exist, out of that. But I understand there is. I haven't looked into
that was our information, was there was a substantial tax.
What we'll do is somebody I'm going to ask if the state would call BISD and see where they are in the recoupment of the value on those properties, and what net has been determined based upon tax obligations, which are always prioritized. But whatever is not taxed is going to get credited toward Mr. Walker's obligation under the court order in this case. So,
Judge, could I just mention one thing? I know we always have a record with your wonderful court reporters there. I'm going back off memory right now, but I thought what we had done for the purposes of restitution and being paid is we agreed on a much lower number, we being Mr. Walker and I, than he thought it could be sold for. I know it wasn't selling for what he had it listed. And we were hoping, it was our understanding that that number that we had on the record last time was what we were going to apply to his credit towards his restitution. And I don't have the number in front of me. I think it was 280,000, something along those lines. I just wanted to mention that was our understanding of what had happened at our last setting, and I am going off my memory.
Well, whatever the credit's going to be, it's going to be a new arithmetical determination. Okay. It's going to be what it actually becomes when the numbers are put together and the taxes are taken out. And then if there is another issue, then I'll resolve it if it has to get resolved. But until, fair market value is, I think that's back in law school. One of the first things we learned in property, right? What a willing buyer is willing to pay and a willing seller is willing to sell it for. And whatever that meets, that's fair market value. And if that can't be determined, it just can't stay in twilight zone. The court will make a determination in abundant fairness and based upon input of all the parties. And if I have to resolve it, then I'll make a resolvement, and then that can be an issue that can be taken up later, but it's going to get resolved one way or the other as expedient as this court can do it, and in all fairness possible to all parties, the obligor and the obligees. So,
Yeah.
Yeah, but I just, I don't believe it's been, of course, what would answer it is the properties, somebody comes up and says, we want to buy those properties. And then that becomes a fair market value determination if that can be, if an agreement can be reached. So that's what he would be given credit for there. That's an easy one. The question then becomes if they're just sitting there and they're not transferred but to a willing buyer, then obviously it just doesn't sit there in twilight zone. It has to get resolved in all fairness, to a defendant and to the people. And we take that up if and when that happens. But there are answers to it. It's going to be done one way or the other. And everybody knows when we're dealing with these things, these can be excruciatingly time continuing, where we can't get things done immediately or quickly as we would want. But the importance is the assets that the defendant did have been, that can be transferred, have been moved over to the taxpayers.
That's right, Judge. I think we did that yesterday, or I'm sorry, last setting.
Yes, and that was what was most important for this court.
Okay.
And again, that is those values which this court understands are significant amounts. We expect ultimately to be liquidated or given credit to the defendant for. The other is what he has been doing as he promised, and that was pay monies while this pay as much as he could toward the balance on restitution, which is a lot of money. 6 figures plus. And we have over $12,000 applied toward restitution, not counting those properties which were on the tax appraised of over a couple $100,000, I believe. But the defendant made promises. Mr. Walker has promised from the outset of this that he is willing, ready, and able to work, and had opportunities from friends or others, acquaintances, to help him make income to pay the minimum of $1,000 per month that he has ordered. That's not being done.
Oh, I thought he was paying that.
Well, as of today, $12,194 has been paid, and over the time that we have, from the time that we have ordered this, that doesn't factor out to $1,000 a month. But let me finish. What I want to know is, are you meeting that obligation of $1,000 per month?
Yes, I have.
Yes, sir, at least. If you can pay more, you can pay more. All right. So that's what I'm concerned about. That's good. That's okay.
Okay.
Because that has been since that order.
Yes.
Important. The next thing is, are you able to pay more than that?
Not at this time.
What is being done? Because you represented, the opportunities were there to make an income that was more than just $1,000 a month if he paid for restitution, because this court has ordered a minimum of 1,000, but I want as much as you're able to pay to the taxpayers.
That's what I've been doing.
So what are you doing to be able to pay more than $1,000 a month? And when, are there any, is there any hope of anything soon being accomplished in that regard to increase this?
Let him know about the two home warranty companies, Calvin.
Yeah, I've applied for several jobs and I got a couple of contract offers with Choice Home Warranty and American Home Shield. But I only get the jobs if they call, they have to need my assistance at the time.
Since when has that been an opportunity for you? Since when? How long have you been waiting?
About a week ago. I applied for several jobs.
Okay. Well, so what are y'all thinking about? Where does it look on that? What's realistically hopeful?
I think that my understanding is currently with his limited income he's getting from his son's company, and I think this has all been reported to Miss Hunter, I believe, and his Social Security payment that he receives monthly. I think he's still the last month or two when he's paying the increased amount of 1,000. I believe he's been borrowing a certain amount to get to the 1,000, to be upfront with you, Judge. And I believe that has been reported to Miss Hunter. And if he can get more money and so he doesn't have to borrow from friends, I think that he could then pay. I used to have American Home Shield insurance. I thought it was a waste of money on my side, but hopefully they'll get him some work to come out there. I could never get anyone to come out to my house, but that's not his fault. That was American Home Shield's fault, quite frankly. But I think that Mr. Walker's doing what he can. I know he'd also sold those trucks before the last setting and paid that money to the county for BISD as well. So, Judge, I don't think I have a definite answer other than right now he's still borrowing some amount of money to make that 1,000 each month. And if he can make more than $400 or $500 additional money, he could probably start throwing a little extra on top of the newly ordered 1,000.
Okay, well, your less than hopeful review of your past experience with that organization doesn't give me a lot of hope.
Well, that was on the insured side, Judge. So,
what state say? Anything you'd like to add?
No, sir.
All right, and all the appeals briefs have been filed?
They will be at the beginning of next week, and then it's entirely in the hands of a different set of judges to decide what to do.
All right. The appeals brief from the state's going to be filed here shortly.
Yes, sir.
So it'll be in the hands of the Court of Appeals, and hopefully an opinion will be determined, a resolvement will be determined expediently.
Yes, sir.
Until then, the defendant continues to be ordered to pay at least $1,000 per month toward restitution payable to the Beaumont Independent School District. And I am not aware of any other assets he personally owns that can be acquired and ordered by the court to pay. Is that what everybody believes? That with the properties from Pleasure Island that have been ordered, turned over, then it's his homestead period that he's left with. Is that what everybody states? Mr. Walker, right?
That's correct.
So it's an income issue now in employment, and And what I will do is review this in 60 days on a status and of where the appeal is and what other income opportunities Mr. Walker was able to acquire. But at the beginning of this, Mr. Walker, I'm going to remind you, you were very optimistic about being able to get employment and work for folks. And that's just not paying off. That optimism is not resulting in an income that you had proposed or expected. And I expect you to vigorously attempt to seek all opportunities for additional income so as to repay the victim in this case as much as possible. Are you doing that?
I am.
Okay. I want you to pass on to the probation office every week an update on what efforts you were making, so I can be confident and satisfied that you are making all vigorous attempts as possible. Who you've talked to, what applications you've made, copies of applications that you make. And I want that weekly. Do you understand, sir? That will be a condition of this bond. And how often do you meet with Mr. Walker?
Every 2 weeks.
Every 2 weeks. Okay.
The most recent job search.
Man. Yeah, I'm looking at something since December, which shows a job search worksheet that does the defendant fill this out, or is he telling you this and you're filling it out?
He fills it out.
Okay, but this is your handwriting.
That's correct.
Okay. And how often are you getting this?
Every 2 weeks.
Every 2 weeks. Okay. And this is a product of 2 weeks right here?
Since December.
Since December.
It's about a month. It's about a month, Judge.
Does he fill out a new sheet each time or just add to this single sheet?
He adds to that sheet and I initial and put the date that I observed.
Okay. All right. So since December, we're looking at 8 independent entities that the defendant has contacted for job opportunities.
Yes.
Okay. And that's since December. Okay, that's good.
There was another sheet there.
Okay, because this is since December 15th. And so that's that's 5 weeks, and that's less than 2 a week, you know. But you said there's more here. Thank you. No. Well, Ms. Hunter is pretty good at keeping bookkeeping accurate, so we got to ramp up the quantity of attempts, don't you think?
Judge, I'm seeing 2 a week since up until last week.
Yeah, it was
If I'm reading it right, 15, 17.
It was 5 weeks, 8 in 5 weeks. So it's less than 2.
Right. I'm just looking at the dates. I'm just seeing the 2 a week up through the last week.
What do y'all think about that? I mean, is that enough? Is that satisfactory? Because number one, nothing's being accomplished except we're making attempts, but we've got these online applications have been filed. That you file that, and that I know, I understand. And how long does that take? I know what an application doesn't take a week to do, but I can understand meeting with people might take longer after this these applications, but most of this are just online applications being filed. Only 4 meetings with particular representatives of potential employers are here. I mean, there needs to be more vigor, is what I'm saying, sir. I know, but I know how long it would take to do an application. It doesn't take that long. Every day, your obligation on your bond is to be striving for income every day. Well, it's arguably, it may not be vigorous enough.
Yes,
What do you think, Mrs. Munn?
As noted on some of these job searches, some places are not hiring. So Mr. Walker has been directed to apply to places that are actively hiring.
Well, he won't know until if they say we're not hiring, then he needs to move on with that. But he's picking up the phone, and if it's a dead end, you just don't drive into the dead end. You turn around and try another, and that's what I want is to be vigorous in attempting to get more income to pay the taxpayers. And I'm not sure that I'm satisfied yet on this. There needs to be more vigor. Anything else? Okay, when did we set a review?
3/27. It will be about 60 days, so hopefully we'll have 3 months.
Yeah.
Yes.
What was the date, Judge? I'm sorry, I didn't hear that.
Middle of March.
3/27.
3/27.
Can I just,
3/27.
do you mind if I check and see if that's spring break, Judge? I'm sorry.
Okay. Yeah, let us know.
Okay, I'll let you know. Your staff's been great working with me, so I think I'm good though. Thank you.
All right. Okay. Yeah. In that period of time, in 2 months, there needs to be more than just that amount of online applications, which are just 8 attempts. Or this court's going to act.
Okay.
Okay.
Thank you, Judge.
You think it's a mistake?
No, sir.
Thank you. We're in recess on this. Get a resetting, please, Mr. Wall.
And that, ladies and gentlemen, is how the cookie crumbles. And that's all I got. That's all the cookies I got. It's been a crazy day. And my little Wolfie is not here. Oh! There he is. Those were some interesting cases, ladies and gentlemen. I particularly enjoyed seeing that Walker follow-up case, and the Simpson Toupe case is something to look forward to for sure. I do want to give a quick shout out to my friend Zach for 5 times the love today, and Great Granny for 10 times the love. You guys are the most specialist, and make sure if you're looking for some more court content, I just want to throw this out there. I don't do this enough. If you're looking for more court content, go to Court Shorts, Law Nerds Unite, great channels. Also visit Cooling with Colin, another great channel to, just kind of tickle all of the court funny bones that you need. But when you're here, you get the best chat in all of court. I just don't know what to say. But, Colin, Zach, Biggie, Mike, all our other friends and creators in the CourtTube community, make sure to go over there, give them a subscription if you don't already have them. Yeah, the Gardener, old Squishy himself, the OG CourtTuber. Can't forget about him. I don't do these enough. But the main ones, I definitely want to just say, hey, Law Nerds Unite, Kulamu Colin, and especially Sovereign Citizens Encounters, Hutch. Some of my favorites. Ladies and gentlemen, I am your lone wolf Usul. I'm your humble curator for these here videos. I am the host of the Court Gallery, and I want to thank you very much for hanging out with me on this Saturday for brunch and court and all the good stuff, all the conversation. But ladies and gentlemen, thank you very much. I have more to come. Keep an eye out. I may do another live, not today. But Sunday's always a hodgepodge. Probably not, but maybe. Definitely every night of the week. We do that 8 p.m. Central Time, 9 p.m. Eastern Time. I just say same wolf time, same wolf channel. Come on by and hang out. Me and Mama will be here chatting about some court cases and probably some other people too. It's great hanging out with you people. I'll see you next time. I am your lone wolf Usul, and I am out. Stay safe, stay warm, stay weather aware. And for all of your winter weather warning storm needs, check out Ryan Hall, y'all.